Ratan Nigam, hold back for a while, Tausif. I come back to you. Mr. Nigam, again, as Tausif is saying, this is not a matter in which you should be concerned. He's saying, how can a BJP government decide on what is there or should be there in Waqf board? Because it's something which concerns the Muslim community, the same argument that Adil Hassan gives. Now, a couple of questions. You are a lawyer. Is the parliament does the parliament have the sovereign function to enact laws? It is challenged in the Supreme Court. Should the Supreme Court be allowed to adjudicate on it? Shouldn't the Supreme Court decide what's the constitution and whether what parliament has enacted is constitutional or not? And more importantly, if the Pasmanda Muslims are not represented in the structures as they exist today and the government has brought in this law, why should we treat the voices of Maulana Madni of Jamiyat, of the AIMPLB and of the AIAMIM as the representative voices, given the fact that Pasmandas constitute a majority of the Muslim community in the country? Desh Ratan Nigam.
Abhishek, in fact, let me answer you one by one, because I've been listening very patiently. Now, Bengal has become a state of sorrow and grief for Hindus. Time and again, and every time Calcutta High Court had to intervene and provide some kind of a relief and give some kind of an independent investigation so that culprits are brought to book. And every time, what we see is first create a violence, then play a victim card. Yes, Parliament is supreme so far as enacting laws are concerned, because our Constitution provides so. Judiciary for redressal of grievances is supreme, and executive for implementing the scheme of the parliament is supreme. This is the constitutional scheme of things. And if a leader, TMC leader says, Mamata Banerjee, that we will not allow the Waqf Act to be implemented in West Bengal, which means contempt of parliament, also an anti-India statement, which should be dealt with very strictly by the central government, because that means they do not want to respect the parliament. They do not want to wait for the judicial outcome from the Supreme Court. This is a very, very serious matter and has to be taken and dealt with very seriously. Now, third, when somebody compares that temples are being run by Hindus, we are not asking that in the mosque management the Hindus should be brought in. There is no question like that. Waqf, nobody is tampering with the membership of the Waqf. Waqf will have Waqifs and the Mutawalis who will be a Muslim. However, the grievance redressal mechanism everywhere in India is a secular one. Please remember Ram Mandir. In Allahabad High Court, Justice Khan had heard, one of the judges. Even in Supreme Court, Justice Nazir had heard it. Now the board here, Waqf board itself had become the investigating authority, then a judge also. That cannot be allowed. You cannot become a judge in your own cause. Therefore, the grievance redressal mechanism is always secular. Even under the Waqf Act, the mechanism is secular. The judicial mechanism is secular. Anybody can deal with it, whether Muslim, Christian, Hindus, Buddhists, Sikh, Jain, Isais. Anybody can be a part of the judicial secular grievance mechanism, which was there in the Ram Mandir case also. There was a Muslim judge also on the bench. Now, the serious question is what should be done today is how to control the rogue state government, which has gone, berserk, not even instructing the policemen to take care of it. The High Court had to intervene to bring in paramilitary forces to control the situation. This is happening every time, whether it is Saraswati Puja or immersion, Durga immersion, or post-poll violence. Please I'll give you n number of examples. The law and order process brought under control on the instructions of the judicial mechanism. So today, the supremacy of the parliament, anybody who challenges is doing contempt of parliament, which is punishable. Please remember, parliament has the power to call for that person and punish.